Good morning. I'm Tracy Wright. I am a partner in Fieldfisher, and I'm going to moderate today. We are really delighted to see so many of you here this morning, and a particular thanks to those of you who have come straight from a party, because I know there are at least 3 that I've seen so far. So we're very grateful to have you here. And we extend that welcome also to those of us who are joining us online. We're going to follow the traditional format of a seminar. We'll do the panel discussion, and then if you have any questions, we'll do questions at the end. Just stick your hand up, we'll pass around the microphones, but we'll do it in that format. If I may, I will start by introducing the panel. So, in the middle, sorry, it's just the way it's written out. This is my partner, Alex Underwood. Alex is a partner in the dispute resolution team at Fieldfisher and specialises in arbitration and litigation. She has a wealth of experience in advising companies, states and high net worth individuals in both commercial and investor state dispute. Alex's recent experience includes cases in Ukraine, Russia, Europe, North and Sub-Saharan Africa, across several industries including telecoms, aviation, hotels and construction. She has experience advising under the rules of the ICC, UNCITRAL, ICSID and African Arbitral Institutes. Alex is recognised in the directories for her work in emerging markets, and Legal 500 comments that, alongside her enviable practice, she finds time to be a huge supporter of the female legal community. She's involved in several initiatives designed to create more opportunities for female lawyers. On the end, we have Jackie MacArthur. Jackie is a barrister at Essex Court Chambers, practicing commercial, public and international law across both litigation and arbitration. She has a particular specialism in international disputes, encompassing investor-state arbitration, public international law, and the conflict of laws. She's described in Legal 500's public international law rankings as hardworking, very clear, very smart, and very thorough, as well as a pleasure to work with. Jackie has acted in numerous investor-state arbitrations, including under the ICSID Convention and the ICC, SCC, LCIA, and UNCITRAL rules. Recent examples include a claim concerning a South Asian telecommunications operator, claims concerning energy interests and airlines in Eastern Europe, and a claim concerning competition and taxation laws in Central Europe. She also acts frequently in proceedings before the European Court of Human Rights and has acted in proceedings before specialised United Nations agencies. And then finally, to my left, Lucas Baston, KC. I still stumble over the KC bit, sorry. Lucas is a King's Counsel at Essex Court Chambers with extensive experience in all forms of international disputes. He's worked in very large and complex commercial litigation, typically involving numerous jurisdictions. Lucas is vastly experienced in international arbitrations. He has acted in several dozen international commercial arbitrations and several dozen international arbitrations, often involving very large claims. His experience covers all major rules. He has worked with applicable law from across Europe, Africa, Asia, and the Americas, and has wide coverage of sectors in which these disputes arise, including, this is a list, telecommunications, oil and gas, mining, construction, power, entertainment and leisure, information technology, financial services, real estate, aircraft, airline, and airport services, media, manufacturing, advertising, taxation, and others. We've got the and others, which I like. Lucas's practice also entails significant work and expertise in public international law, including before international courts and tribunals, and also litigation in the UK, both before commercial and arbitration courts, administrative courts, that involves element of public international law, such as issues of sovereign immunity, susceptibility of state assets to enforcement, WTO law, and other matters. He is adjunct professor of international arbitration at Pepperdine University and visiting lecturer at King's College London in investment arbitration. That is our panel, yeah, and you will tell from those introductions that they are all extremely experienced in this area, and we are really grateful to them for joining us today and giving up their time to speak to us. So by way of a brief introduction, the purpose of investment treaties might be summarised quite discreetly as being a treaty to protect investors and promote investment. So it seems fairly straightforward, perfectly easy to deal with, but maybe not so in practice. Treaties protect the unknown investor. They have to work across a vast range of sectors and interests. The language in treaties is often broad, and what the investor expects and what the state might be willing to offer in terms of protection can be at odds. Investors who believe a state has fallen short resort to arbitration. Investors must prove the breach, and arbitrators must consider the facts and interpret a state's obligations. But the question is what standard to use in this to assess a state's actions, and by reference to what considerations. The topic for today's discussion is proportionality in investment arbitration, and we pose the question, is it a sleeping giant of a concept in investment arbitration? So to start the discussion, Jackie, could you please give us an introduction to the subject and tell us what proportionality is?
Thanks, Tracy. I'm going to kick off by talking about proportionality generally, and then I think we'll move from there to proportionality specifically as it's used in investment treaty arbitration. Especially for those who don't have an extensive background in proportionality, broadly speaking, it's a tool that is used to assess whether government action is justified. It provides an analytical framework for balancing, on the one hand, a general or a community interest goal against, on the other hand, harm to individual rights or interests that might be caused when a government pursues that general goal. The broad theory is that proportionality works on two different levels. It provides this analytical framework to the actual government decision maker to make sure that when they're pursuing the public interest goal in question, they have a way of making sure that they're giving proper consideration to countervailing harms that might be caused, countervailing harms to rights or interests, rather than simply riding roughshod over those rights or interests without giving consideration to that harm. On the second level, it then operates to provide a reviewing court or tribunal the tools to assess what the primary decision maker has done, so as to avoid taking a one-sided approach that on the one hand only gives consideration to the individual harm, or on the other hand only gives consideration to the importance of the public interest goal that's being pursued. On both of these levels, the primary and the review level, the goal of proportionality is to give a framework for identifying all of the relevant considerations and placing them properly in relation to each other, to avoid the situation where the decision maker of the reviewing court or tribunal essentially puts their finger in the air and declares that a measure is or is not justified or should not be pursued based on their gut instinct. Proportionality is not used particularly widely in investment treaty arbitration traditionally, but it is firmly established in other areas of law, especially in human rights law. The European Court of Human Rights and other specialist human rights courts use proportionality extensively. It's also used fairly extensively in European Union law, in certain civil law traditions, and actually even increasingly in the common law. The UK, under the influence of the EU and European Convention of Human Rights Law, has increasingly adopted proportionality as an analytical tool for assessing government action in administrative law, but it's also long established in certain forms in areas like United States and Australian constitutional law in order to assess impact of on individual rights or freedoms that are protected by the Constitution. The way that it operates varies across these systems, but what's usually accepted as the sort of classical model of proportionality is the one that's used by the European Court of Human Rights. And this operates by reference to three main steps of analysis. The first step involves identification of a public interest, which the government says justifies the action that it took. At the very least, this first stage of identifying a public interest provides the grounding for decision making by requiring a government to clearly identify and set out and justify the public interest that it says that it's pursuing when it takes a particular measure. Depending on how deferential a review of government action is, the review may simply accept what the government says as the public interest and say, yes, we accept that that's something that the government should do. If the court or tribunal wants to be more extensive in its review, it may require a government to put forward evidence that this represents a genuine public interest good or need. And the court or tribunal may also take into account evidence that the measure was not in fact motivated by the public interest now asserted, looking at, for instance, ministerial statements, position papers, government reports, explanatory memoranda, to understand the true reasons why a government acted. The second step in the analysis is to assess whether the measure or action that's being challenged truly corresponds to the public interest that's being put forward by the government as the justification. If there's not a genuine link between the two, then the measure can't be justified by the public interest sought to be achieved and must instead be explained by something else. Difficult questions of proof can arise at this level, such as how is that connection to be analysed, and what if the measure might bear fruit in pursuit of the public interest in future, but hasn't yet done so? And these are open questions in the law of proportionality. The third step in a proportionality analysis is to balance the public interest justification that's being put forward by the government against the effects on an individual or a group of individuals who say that the measure in question has harmed them. And this third step in reality is where the real meat of the proportionality analysis usually lies. Once again, depending on the degree of deference that's given to government decision makers by a reviewing court or tribunal, there can be different approaches to this step. If a high degree of deference is afforded, then the court or tribunal that's reviewing a measure may say that the decision to take the measure will only be found unlawful if it's manifestly without reasonable foundation. A medium level of deference will involve a straight out balancing of the importance of the public interest against the seriousness of the individual harm caused. And then in certain areas where there's a low degree of deference afforded, the court or tribunal might ask, could the decision maker have achieved the public interest goal in any other way? Was this the last available alternative in order to pursue that public interest goal? A final point outside of these three steps that informs all of them, and that I've already touched on, that's really important to understanding how proportionality analysis works, is what's sometimes called deference, or in some areas of some systems of law is called a margin of appreciation, which refers to the extent to which a court or tribunal that's reviewing a government measure on proportionality grounds will second guess assessments that are made by the decision maker. It usually attaches to step 1, identifying the public interest goal, or to step 3, balancing public interest versus effect on individual, but it can also attach to step 2. The justifying theories for according deference or a margin of appreciation to a government decision maker usually boil down to some idea of legitimacy. The government decision maker has a democratic mandate or a governmental mandate to make decisions of this kind, and a reviewing court may be further down the pecking order in terms of that kind of mandate. A second justifying theory is that government decision makers, with all of the powers and resources of the government behind them, might have a better institutional capacity for assessing things like the weight of a public interest and assessing the kind of evidence that's usually used to inform a proportionality analysis. And in reality, the degree of deference that's used for a proportionality assessment will in practice determine how rigorous proportionality analysis is in a given case. That's kind of a broad canter through.
Thanks, Jackie. So Lucas, we're going to move on to consider how proportionality shows its face in investment arbitration now. Based on Jackie's introduction, can you give us a summary of the current play of proportionality in investment arbitration?
Yeah, sure. Thanks, Tracy. So really this set of comments I'm about to make is to set the platform for what we'll be discussing over the rest of this session. It may be familiar to some of or all of you already, but there are 4 ways in which proportionality comes up in investment arbitration. The first, the most contentious and probably the most interesting for today, is whether or not proportionality is a standalone component of the fair and equitable treatment obligation. And by standalone component, what I mean is, if a state adopts a measure and an investor challenges that measure in the context of an arbitration, saying it's a disproportionate response to whatever the mischief was it was seeking to address, can that by itself be a breach of international law and the FET obligation? Now, as you can imagine, that's quite a contentious idea, that a state, simply because it does the right thing, but maybe goes a step or two beyond what it should have done, can therefore be in breach of international law. Tribunals, in assessing this at the outset of these types of arguments, were quite uncertain about this. Some rejected the idea that this could be a component element of the FET obligation, an outright legal finding that this is not something which constitutes a breach of FET, or indeed ever could. As time went on, though, and the cases started to develop more momentum around the concept of proportionality, it has now become more accepted that it is a standalone component of the FET obligation. Simply acting disproportionately by a state can be a breach of international law, leading to a significant award of damages. What's difficult, though, is that even though on the FET obligation we're through that first gate, it's still not settled, indeed far from settled, what the legal standard is that constitutes a breach of proportionality. You just heard a very clear explanation from Jackie as to how other systems of law will understand that concept and apply it. And there are very sophisticated analyses of this in Strasbourg and other areas, for example. But unfortunately, we are still in a state of flux when it comes to investment arbitration tribunals articulating a consistent legal standard for what is really quite a large and powerful concept when it comes to proportionality. I won't go deep into cases, but I will say that the starting gun was fired by a case called Charan in Spain, and they attempted to define proportionality. I mean, what a joy that would be. You sit down at your desk and someone says, what's proportionality? You say, oh, all right, I'll get to work. And off they went, they wrote their decision, and they invoked other concepts in order to give content to proportionality. I'll come on to a bit later about the difficulty of using proxy concepts to define a target term. But for that case, Charan in Spain, they drew on concepts of capriciousness, necessity, and also the degree to which a state measure changed the playing ground on which an investor operated. So that was the touch point. That's where we all thought this was starting, that proportionality was tied into concepts of capriciousness or necessity. Certainly necessity was a very familiar idea under international law. But unfortunately, while subsequent tribunals certainly nodded to the Charan formulation, they didn't adopt it. They then went and sat down and wrote their own definition of proportionality. And we've gone some way through a number of cases now, many of which seem to be against Spain in relation to their renewables policy. And the most recent articulation, and in my view, the one that has really started to get to grips with the underlying content of the concept, is RWE and Spain. And there, the test is articulated as having two parts. A measure will be proportionate if it is suitable and necessary. Suitable is a relatively undemanding element of the test. It simply requires that there be some connection between what the state was trying to do and the measure that it implemented. So it's a bit of a free pass. There's a lot of deference that goes into that. But then the necessity element of this test is much more demanding. It's not articulated by that tribunal at the same level that customary international law defines necessity, but it does require an analysis of whether there were any less restrictive means to achieve the same outcome for the state. So you have here a real endorsement of the idea of necessity as the underlying foundation stone of proportionality. Now, Alex, I'm sure will talk more about FET and proportionality when we come to her section in a moment. But the other three areas I'll touch on very briefly because they're much more established and less in flux. The first is that proportionality is of assistance when determining whether an indirect taking of property has occurred for the breach of an expropriation provision. Everyone's favorite case, TechMed in Mexico, which I think we're not allowed to say anything nice about, did a very good job of defining proportionality in my view. This isn't the paragraph 154 that everyone decries, but elsewhere in the award, the tribunal sat down and said that when there is an indirect taking or there is a measure that impairs the substantial value of an asset, that measure needs to be proportional to the public interest behind it. So if you are seeking to regulate the cleanliness of a river, for example, you cannot say that there shall be no business within 1,000 kilometres of the river. That way, that's one way to keep it pristine. That would be seen as a disproportionate interference. By contrast, of course, if you're saying you cannot pump your refuse directly into the river, that would be seen as a proportionate response. And the idea of expropriation is therefore deeply tied to this. The other two areas are effectively direct transplants from broader public international law concepts into investment arbitration. The preclusion of wrongfulness found in the concept of necessity under international law has its direct placement within investment arbitration. I think we all followed the Argentina cases about 10, 15 years ago, where they articulated that test quite extensively. And then the last one, the little tail on the proportionality dog in the concept of in the context of investment arbitration is countermeasures. Countermeasures under international law, set out in Article 51 of the ILC article, have a number of criteria before they can be lawful, and one of them is that it's commensurate with whatever the original breach that the measures are responding to. And that concept of being commensurate has often been described as requiring proportionality. Chris Greenwood in the corn products in Mexico case is probably the leading articulation of how this concept operates in the context of countermeasures in investment arbitration. So that's the mise en scène in relation to investment arbitration and proportionality, and I think now for the time to sort of get stuck into the debate.
So, Lucas, is proportionality filling a gap?
Yes. I mean, I think the short answer is yes. Now, fair and equal treatment's like one of those clown cars, right? Where just another clown seems to cram in, you're not really sure what's inside the car anymore. And so concepts which can breach FET seem to be this sort of heterogeneous kind of amorphous list. Some of them very clear, legitimate expectations, for example. I think we all know a breach of those is a breach of FET. Arbitrariness is, again, a very oft repeated component or proxy for the FET test. But one of the problems that I think exists in relation to FET and sort of the clown car that it sometimes seems to represent is that at least in the early days, arbitrators were trying to grapple with what those words, unfair and inequitable, meant. And again, that's not easy, right? Those early arbitrators, for whom we owe a great deal of gratitude, they sat down and they basically asked to define these terms. I mean, I don't know where I would have ended up if I didn't have the guidance that we now have from the last 2 decades. But one attribute of what they did was at times they would reach for diagnostic tools and at times they would reach for proxies. Diagnostic tools are those types of analytical tools that allow you to tell whether a primary norm has been breached. Legitimate expectations is a very good example of this. Legitimate expectations itself is not a primary norm of international law. It's a way of telling if there has been a breach of FET. By contrast, arbitrariness is often held up as a primary norm of international law. You see it throughout the International Covenant of Bill of Rights. You see it in human rights law. You see it in EU law as well. And so this became a bit of a melange of concepts as to how FET could be breached. Sometimes you'd have concepts which allowed you to say, that's a diagnostic tool which leads me to prove a breach of FET. And sometimes you'd have proxies, where basically it was just saying, well, I'm not sure what fair and equitable means, so I'll just reach to what feels like a similar concept in international law, like arbitrariness or reasonableness or those other types of examples. So where I think proportionality has real room to grow is because, as Jackie said, it is a diagnostic tool. It is a method of analysis that is not seeking to be a primary rule of international law, but is a way in which you can prove a breach of a primary rule of international law, namely the FET obligation. So my own view is that the reliance we place in FET analyses on things like arbitrariness or reasonableness or coercion or bad faith are likely to slightly slide away from the more rigorous type of analyses that you see tribunals undertake. And concepts like proportionality, certainly legitimate expectations, are going to rise in terms of their utility because they are diagnostic tools rather than just proxies, substituting one set of words for another.
Thanks. Alex, I'm going to ask you to comment on that as well, proportionality fills the gap and whether we need it. But before we do that, Alex, can you maybe just give us a little rehearsal of the components of FET?
Yeah, happy to do so. The FET standard, as you all know, appears in most bilateral investment treaties and in most investor state treaties as well. but it's not uniform across those treaties. So you see some examples where you have lists of examples of how the measure might be breached. In assessing whether a state's actions are fair and equitable, obviously tribunals have taken different approaches. They've got a margin of discretion given the breadth of the standard. But conduct likely to breach the standard is where it's conduct likely to breach the standard is where the harmful conduct is arbitrary, grossly unfair, unjust, is discriminatory, or involves a lack of due process. And the standard tends to encompass the following principles. So as Lucas mentioned, respecting the investor's reasonable and legitimate expectations, not acting in an arbitrary or discriminatory manner, being transparent and consistent, acting in good faith, respecting due process and procedural propriety, and the topic of today's discussion, proportionality. So we could easily devote a seminar to each of those topics, but to turn to your question, which is, does proportionality fill a gap? I think it does. In the context of FET, proportionality provides a framework that enables arbitrators from different cultural backgrounds who may have different instincts and ideas about what proportionality means to discuss and agree how an investor's rights should be balanced against the state's right to regulate. And I think that's a really important tool that's required to enable cultural differences to be distilled into, as Lucas describes it, a diagnostic tool. For example, in considering an investor's reasonable and legitimate expectations that the regulatory framework will not change, or that the state will abide by previous decisions or assurances provided to investors, it's useful to consider whether the state's conduct in amending that regulatory framework or deciding to adhere to a previous decision was proportionate in the circumstances, and ensures that both the investor and the state's perspectives are taken into account. In that way, the tribunal may balance those competing interests, and the rights of the investor to have protection for their investment and the autonomy of the state to make decisions can both be taken into account. As Lucas has mentioned, there is, however, a variation amongst tribunals' practice when considering the role of proportionality in the context of FET cases. While perhaps there is some movement towards a settled set of principles, it's taken time to get there. Taken time to assess whether proportionality is a sister principle of reasonableness, necessity, or other concepts. So the path has taken to get to this point is somewhat winding. There is still something of an open question as to what future the concept has in investment law and how it will be used to resolve some of the big questions that are coming. For example, we think proportionality is likely to have an increasingly important role in investor-state disputes as states strive to meet their net zero targets and other ESG commitments. States will be bound to change their regulatory environment in response to this pressing need, and in my view, proportionality will have an important role to play in that process. We've seen a remarkable uptick in climate change disputes over the last few years. There are obviously the much discussed intra-EU disputes under the Energy Charter Treaty, mainly brought by fossil fuel-powered energy generators, arguing that their rights have been infringed by the acceleration of moving towards a net zero target. We've also seen actions brought by renewables companies, arguing that their rights have been infringed by the removal of green subsidies across Europe. It's essential, in my view, that investor-state arbitration evolves in a manner that allows states to legislate to meet what the UN Secretary General described as a direct existential threat to humanity. Investors too want some certainty about how the tribunals will balance the state's rights to regulate with the protection of their investments. Companies can manage risk and they can predict and quantify. A consistent approach to balancing these competing imperatives will help.
Jackie, what's your view?
I agree with what Lucas and Alex have both said, and picking up on a few of those points. I think that Alex is absolutely right that a key advantage of proportionality is that it accommodates both state interest and individual interest or right. I think also it's really useful as providing an analytical framework and a way of reasoning what, in essence, tribunals often actually do, which is to balance different harms and interests. But it provides not just a way for them to analyse those in a coherent way, but also a way for them to explain what they're doing in a way that contributes to a consistent and coherent body of case law that can then, as Alex said, be used to guide what states and individuals do and how they act. A criticism that's sometimes made of proportionality is that it seeks to replace some of the existing and accepted diagnostic frameworks or tools that Lucas and Alex have both touched on, and in particular that it seeks to replace arbitrariness as a standard, but actually goes beyond, so it's a more rigorous standard of analysis than arbitrariness is, and therefore holds states to a higher account. A similar argument is sometimes made in respect of legitimate expectations, that it seeks to replace that. I think that while that's sometimes true, I think that it can be, it's an important tool for replacing what can sometimes be flaws in these individual substandards of FET, in that some of the individual substandards, as Lucas says, because they're used as a proxy for fair and equitable treatment, which is supposed to be the overarching standard, they can actually fall short of what that is trying to encapsulate. In particular, by being essentially a yes or a no standard. Did the state flagrantly breach its own laws? Yes or no? Did the state depart from promises that it made to an investor? Yes or no? If no, then therefore no breach. The state can do what it wants. If yes, then therefore breach, no matter how important the public interest that was being pursued, the individual has a right to a remedy. The advantage of proportionality is that it provides a more nuanced approach that allows all of these things to be taken into account and weighed in a reasoned manner against each other to provide an outcome. And I think that's the real beauty of the doctrine and how it can be applied to assist in investment treaty arbitration.
I mean, so you've all agreed that there's room for it. And that it has a place. Jackie, can you just, you've started to sort of speak about it there, can you flesh out a bit more the components of proportionality test and how it will fit into FET?
Yeah, absolutely. Using just as a shorthand, the three-step approach that is used often in human rights law that I ran through before. Step one, identification of types of legitimate interest. That's reasonably easy to do, and it's something that investment treaty tribunals often actually already do, even though they may not signpost or flag the extent to which they're doing it. So, for instance, in the space of renewable energy cases, the public interest that was being pursued was fiscal solvency and the balance in the energy market, more particularly. Another interesting example is the case of EDF in Romania, in which the public interest that a tribunal held was legitimate was to harmonise Romania's domestic laws with EU requirements on duties and taxes. And in this case, the tribunal assessed the measure and assessed the extent to which it could truly be said to be justified by the public interest that was being asserted. The tribunal looked even at legislative materials, at the reports that were put to Parliament, at what ministers said about the measures in question. So it's a demonstration of a tribunal exercising some oversight rather than taking government assertions, the nature of a public interest at face value. And this is what proportionality analysis permits. The second step, the connection between a measure and a public interest. The renewable energy subsidy cases, I think, provide, again, a useful illustration of that, how this can be done. And in particular, Watkin Holdings and Spain, in which the tribunal placed particular weight on the fact that a change to the tariff regime at issue in the case was a change to tariffs on wind energy, which only played a marginal role in the kind of public interests that the state was said to be pursuing. And this led the tribunal to question whether there really was a connection between the asserted public interest and the measure in question. And then the third step in the proportionality analysis, where I've said the meat usually arises, balancing of public interest versus effect on individuals. I think this is something that tribunals often attempt to do already, but proportionality analysis provides a different way of approaching this. And so some of the considerations that are already taken into account in FET analysis fit really neatly in here. So for instance, whether changes were retroactive, whether changes in law or in regulatory framework allowed a period of time, a transitional period of time in which an investor might adjust what they were doing in order to take account of the coming changes. Whether there was a violation of specific commitments that had been made to investors, whether there was a change to laws rather than an outright violation. These are the kinds of factors that are already at play in different components of FET, but in proportionality analysis, they can all be taken into account in this third step.
Alex, can you, building on that, can you talk to us a bit about proportionality in the context of rectification claims?
Right. So a key area where we see proportionality considered is in the analysis of a state's police powers defence to claims of direct or indirect expropriation. So just by way of reminder, the doctrine of police powers, or the right to regulate for the protection of public interest, provides that where appropriately exercised, a regulation that harms an investment does not constitute an expropriation and does not therefore entail the payment of compensation. The police powers exception was best codified in the Harvard Draft Convention on the international responsibility of states for injuries to aliens, and particularly Article 10.5. And this provision was adopted by the tribunal in Saluka and cited by many other tribunals since. So just by way of reminder, Article 10.5 provides that an uncompensated taking of property shall not be considered wrongful, provided it meets the following four criteria. It is not clear and it is not a clear and discriminatory violation of the law of the state concerned. It's not the result of a violation of any provisions of Article 6, which concerns denials of access to a tribunal, or Article 8, which is the denial of a fair hearing. It is not unreasonable. It is not an unreasonable departure from the principles of justice recognised in the principal legal system of the world. Putting aside what principal legal of the world now means as the balance of power across the globe changes, it is not an abuse of the powers specified in this paragraph for the purposes of depriving an alien of his property. So the principle of proportionality comes into the third limb of the test. An alternative description of the standard for the application of police powers is that articulated in Philip Morrison, Uruguay. The tribunal in that case set out a three-limb test, which is that for a state to avail itself of a police powers defence, the measure at issue must be taken bona fide for the purpose of protecting the public welfare, non-discriminatory and proportionate. In most of the cases where we see police powers have been pleaded as a defence to a claim of expropriation, the tribunal has been able to dismiss the defence without conducting the proportionality element of the test. In our experience, the defence tends to fail at the first hurdle of establishing the bona fide reason for the exercise of the regulatory power. That might either be because, in truth, there was no such public interest in the regulation that causes the taking, or it might be because there's insufficient contemporaneous evidence of the state's reasoning. Interestingly, this step would also fail the first stage of the proportionality test of identifying the public interest. In any event, it's not sufficient to evidence this at a later date and come up with ex post facto justification for the measure. And we've often found that contemporaneous evidence in the form of political announcements reveal the true reasons for a regulatory measure that results in a taking. They might be to fulfill some political objective or otherwise clearly retaliatory or discriminatory. So in our cases, we rarely get a reasoned analysis in awards of the proportionality arguments submitted, which is a shame because, and it's frustrating because sometimes those arguments can appear to be ships passing in the night. And I think that's because there's no agreed methodology of assessing the tension between a state's right to regulate and an investor's right to its investment. This may explain why in recent cases where we acted for an investor, the state involved invoked a police power of defence. The state did little more than simply assert that the measure was proportionate. There was no real attempt to justify that statement either with evidence or further pleading. Unfortunately, the practice of tribunals varies, and we've seen in Occidental 1 and also the Argentina cases that tribunals may well disregard states' reasons for actions, holding that the state was obliged to maintain a stable regulatory environment or to refrain from acting inconsistently with its previous decisions, regardless of the circumstances. Hopefully, we're now moving away from that approach, and it's much more common now to see tribunals hold that any changes to laws or policies or inconsistent treatment of investors must be justified on public policy grounds, and that entails some balancing of the interests of the investor and the host state's right to regulate. And this is where proportionality, I think, has a key role.
Thanks, Alex. Obviously, one of the things that flows out of all this is impact. What does it mean? So, Lucas, can you move on to that and consider for us the potential implications for the state recognition and how the balance of individual investment over wider public interest can be managed?
Yeah, thanks, Tracy. I mean, I'm not sure you're allowed to host an event around investment arbitration without talking about how much investment arbitration is suffering from the backlash. You know, that's a single word now which you can say in company like this, and everyone sort of, you know, chuckles and nods and has lots of knowledge of what is happening. But the backlash for me was first and foremost a backlash to the fair and equal treatment standard. Now, I'm sometimes criticised when I say that to people because they point to any number of other features of the investment arbitration system and say, what about those? What about the way in which arbitrators are appointed? What about the way in which expropriation was defined liberally? What about the way in which there are no general exceptions like there are in other international economic treaties? And I accept all that. But fair and equal treatment was the flashpoint. For those who practice in the area relatively regularly, TechMed 154 is just a shorthand for where the absolute crux of the problems around investment arbitration began. Now, that might not be a very fair assessment of that one paragraph and those poor 3 arbitrators that wrote it, but that is where the beginning of this backlash really can be traced to, in my view. And when you look at paragraph 154, what you notice is that there really is that yes-no type dichotomy that Jackie referred to, where you can look at the test in each of the individual sentences in that paragraph and say, all right, I can reach a yes-no answer to that question, and therefore I've proven a breach and proven state responsibility under international law. No small thing. Lacking from that explanation of FET, which was present in other parts of that very decision when they were talking about expropriation, was something a little more nuanced, something which engaged in that balancing exercise that both Alex and Jackie have touched on. And so for my part, where I think proportionality came a little bit too late, it's a real shame that it didn't really get much carriage until Judge Crawford in Bluesen in Italy really came to town and said, this is what it means. The real shame of that is that it could have been a much more ameliorating force in the context of the early days of investment arbitration and FET breaches. So can proportionality at this point in time of the development of the system have that ameliorating force? It might be too late, frankly. The backlash is a thing. It has happened, and its consequences are unfolding in front of us. But maybe as a reaction to that, we'll start to see a greater movement towards this weighing and balancing type of analysis, the embracing of a diagnostic tool rather than just sort of the word salad that you sometimes get when trying to understand what FET means. And if it goes further down that path, and legitimate expectations with its really quite sophisticated now diagnostic tool, and proportionality with its emerging diagnostic tool, play bigger roles in the way in which tribunals assess a breach of FET. It may well be that that is the type of substantive response to the backlash that makes the system more viable, more acceptable to the constituting entities, the states. I don't know if it's too hopeful to look at proportionality and sort of hang over its neck the sort of the future of the system and the response to the backlash. But it is an area where, put aside all the quite superficial responses we hear towards the backlash, you know, let's kill the MFN clause, let's pull out of all the treaties, all those types of sort of eye-catching but really quite sort of, you know, shallow type of responses. Proportionality might be an area where practitioners, arbitrators, participants in the system are able to take a slightly more nuanced approach in a way that therefore is more justifiable. I sometimes find when I'm reading awards that say, look, this is abusive, or this is discriminatory, or this is a lack of transparency, that what I get are those words at the top of the reasoning, a whole recitation of the facts that I've already read at the start of the award, and the conclusion which says, therefore, there was a lack of transparency or what have you. And it's very hard as a person trying to understand what you are then going to argue in your next case, very hard as a person who participates in the system and wants to see it improving, to accept that. So I think much greater hope, maybe in vain, but still better hope, when it comes to using principles like proportionality and legitimate expectations as sophisticated diagnostic tools when determining a breach of FET. Much more hope for the participants, the creators of the system, to say, we accept a system that is thoughtful and nuanced in that way. Just like we've seen acceptance of this principle in all those other fora that Jackie touched on earlier.
And then again, leading on from what you're saying, Lucas, talking about backlash. Jackie, can you give us some examples where that is now, we're seeing that?
Well, the big one, obviously, is the Energy Charter Treaty, the recent wave of withdrawals by EU member states, many of whom say, look, the reason we did this is because we have to pursue public interest goals, especially climate change goals. We have to take measures that restrict the ability of individuals, often foreign investors, to undertake actions that are polluting, to undertake actions that contribute to climate change. And we feel that there is a danger that under a treaty like the Energy Charter Treaty, we will be found in breach of our obligations and will be required to pay compensation in order to pursue these undoubted public interest goals. And I think that the greater use of a tool like proportionality may contribute to ameliorating that concern, because, as Lucas said, it reassures states that their public interest goals and the fact that they're genuinely pursuing an important public interest goal will be taken into account in assessing the question of whether there's been a breach. I think the other thing that is important to remember about proportionality is that it permits an upfront consideration or tackling with the doctrinal question of deference or margin of appreciation. To what extent should a reviewing court or tribunal stand back from engaging in a close analysis or a close picking apart of a particular measure that's being used in pursuit of a public interest goal? And so the greater adoption of a tool like proportionality, which will therefore entail tribunals tackling this question head on, then also allows states a measure of reassurance about the extent to which they will be given a margin of deference in an assessment of what they're doing.
And I'm going to throw the last impossible questions, Lucas. Which you're going to be asked to.
I feel like I should have had some warning.
Well, I'm going to ask you to touch on, I don't know how you can do it in like 30 seconds or whatever, but the role of the arbitrator. So a couple of minutes just considering the role of the arbitrator in all of this and proportionality sitting in there. It's like a whole hour.
Compressed into 2 minutes. And obviously the starting point is what we learn in school. We're all brought up, whenever we are taught heuristic thinking, to avoid internal contradiction. But there is a benefit, I think, to embracing the fact that sometimes when we think through issues, having a degree of internal contradiction is worthwhile. Like Walt Whitman said, I am large, I encompass multitudes. But the reason I'm prefacing with that is that I've spent much of my time today talking about the way in which proportionality is a good thing. It's a tool in the hands of the arbitrators, which allow them to be nuanced, responsive, fact-sensitive, and so on. But now to contradict what I've been saying around that, I do think that one of the challenges that we have in this field is that arbitrators are asked to do a lot. They're asked to be a lot. You need to have people who are not just good lawyers, but often are highly numerate, able to understand and deal with discounted cash flow valuations and so on. And what we are doing now by saying, and proportionality is another trait that you need to be able to deal with competently, is asking them to go another step forward and to be experts at weighing in the balance those types of considerations between public interest and individual legal rights. It's a very hard thing to do. The public interest that we see in these cases, they're not sort of limited to really quite technical legal points. They're asking people to assess, arbitrators to assess, the right to a clean environment, the right to health and safety in your local neighbourhood, the right to clean water and things like that. And so in circumstances where that is in the balance, I think that the role of the arbitrator is very important, but also very difficult. And so the type of experience I think we need from arbitrators are the type of experience that you might see on the Strasbourg court, where people are just trained over years of human rights litigation to understand concepts of public interest and the degree of deference that needs to be afforded to a sovereign in terms of deciding what is a public interest and is not. So maybe my answer in a nutshell, Tracy, is that as much as I support this topic, and I support the extra weight that is put on the concept of proportionality in investment arbitration, I do have a fear, speaking directly, that arbitrators are currently not equipped to do it. They come from a commercial arbitration background, an investment arbitration background, maybe a broader PIL background. But I challenge you to name 5 arbitrators that come from a human rights litigation background. It tends not to happen. But those are the people I think that we need to see more of on tribunals in order to give real oomph to the concept like proportionality. But will it happen though? I don't know how many of you are going to call up your clients tonight and say, look, this is the type of person that I'm going to appoint to our tribunals. Maybe not. Maybe it's just asking too much of arbitrators.
Maybe so.
Whilst I agree with that, I think if we can coalesce around a test and a structure around what proportionality means, actually that's a tool that's helpful to the arbitrators. It's helping them think through that process. And I think it's a balancing act that shouldn't be ignored. So yes, we're asking the arbitrators to do a lot. Let's give them the analytical tools to do that, rather than say that the principle shouldn't be applied.
Yeah, practitioners definitely have a role. I remember seeing Gabrielle Kaufman-Kohler give a speech where she said, I am telling you, this was to a very large audience of practitioners, I am telling you, I do not like pleadings that list the case, copy out the facts and the reasoning, and then get to the end of that long list and say, therefore there is a breach in this case.
I'm right.
Yeah, exactly. You know, sort of the type of brief that maybe the same practitioner has used 10 times in a row. But that means that practitioners need to be willing and competent to say, I'm going to get to grips with the hard part of this and help the tribunal go through it. So you're right, it's not just asking arbitrators to overnight become better. Practitioners.
Yeah, and we all need to get better at, as I said, in the cases that we see, someone just uses the word proportionality and says, therefore we were acting proportionately, without actually explaining what that means or what the decision-making process was that they went through in order to reach that regulatory decision. And perhaps that's something that we should be encouraging states to do, is to, when they're considering a regulatory measure, actually write down, you know, what are their reasons for making that, taking that choice, and not taking some of the alternative choices that might be less harmful to particular investors.
Which complies with that kind of first theory about proportionality that operates on 2 levels, as a tool of review, but also it's something that primary decision makers should be using themselves as well.
That, Jackie, was a perfect end because you put it all the way back around. Thank you very much. Just with an eye on time and not wanting to deprive anyone of the opportunity to have a drink, I'd just like to ask anyone if they have any questions. Oh, I had one prepared because I thought, anyway, there we go. Let's start.
I'm going to start with your last comments about what you want to arbitrate. So, but I'm first going to disclose that I am an arbitrator. And I was also a general secretary for many years with the in fact. But I just wanted to say how I feel about this question of FET, as you have mentioned, is a very vague term defined in treaties. I think that we need to start with thinking how arbitrators have to do. And what they have to do is to interpret the treaty. So they have rules of treaty interpretation, which basically force them with the text and don't necessarily allow them to go much more depending on how creative we want it to be. And I have seen many briefs in my life in which the parties are only bringing to you the definitions given by other investor state awards. And how much further can you go? And I will tell you my personal thought about this is that you can go further and you should go further, because why would I need to listen to TechNet? I should go to the sources. What is there? What is equitable? And there are numerous law sources out there. And I think arbitrators should be entitled to go to them. I don't know if any of you ever had the chance to read the Karen versus India award before it was annulled, in which I was one of the trillion executives. And I have to say, it is, I think, available on your media, although actually the PDF was not. We did attempt to go and define, but go to the sources of public international law. The problem is, what happens if the parties haven't raised them? We did it anyway, and it was annulled for other reasons. This was annulled by party agreement. But in any event, what I'm trying to say is that we need to give the arbitrators tools. Take them to the public international law sources. Tell them, this is just a comment, but you need to make sure that they have the tools. And it is true that there might be some arbitrators that are maybe a little bit lazy and will rely on what, say, okay, yeah, and it's fine, but I think that we need to scratch a little bit beyond the surface. And if council will give the arbitrators those tools, it will even be better, because as a matter of due process, you will be within what the parties have done. So that was just a comment. But I actually have I have numerous questions, but I don't want to monopolize the conversation. I have one specific one, which is, I think that the short question is, what is the impact of proportionality on damages? And I would say that the long question, and we're just going to elaborate a little bit, is, does it make a difference? Because proportionality, the way you have described it, it goes to whether there is a breach, right? So, but if there is a lack of proportionality in FET, does that mean that the breach is smaller and therefore the damages are also smaller? And if we have a breach of proportionality in an indirect expropriation, what does that mean? Does it mean that there's a full taking and therefore the damages continue to be the full? I mean, is there, so I just would love your comments.
Yeah, sure. I mean, a fantastic question. I mean, it's one of the sort of the great weaknesses, I think, in investment arbitration at the moment is still the cartilage issue of causation. And it feels a little bit like establishing jurisdiction and breach is the first half of the match. And then everyone sort of goes off for oranges and comes back to talk about damages. Causation, I think, is emerging as a more prominent topic with sort of more hard-fought things around it. But the idea of whether or not a breach is lessened in terms of its quantifiable impact, if it's a breach by reference to proportionality, I think is a very interesting one. If a state has done something which is acceptable other than going a step too far, and say it's one step too far, should that not be thought of as a mitigating circumstance, for example? And I think there are real arguments to make here. I haven't seen them made yet myself, but I'm sure that there is room for them. The Crystal Lakes test, which everyone talks about when sort of coming to quantify damages, that's ample room for this. That's a two-step test. The first is that the tribunal needs to be sufficiently certain that the breach, whatever it is, has caused loss. And then they have a wide margin of discretion as to how to value that loss. Concept of proportionality in the formulation of loss, but also concept of proportionality as leading to a relatively minor breach. Both have a voice there. They can both be heard as a relevant part for how you quantify a loss, what number you reach. So very much watch this space. I don't want to say that proportionality is the answer to everything, but I do think it is an answer to some of the valuation questions we face.
And in Crystal X, which was a forward-looking valuation, so a loss of profits valuation, it completely ignored the question of the level of investment made by the investor, but we see it operating and as a sort of sleeping giant, an unspoken rule of thumb about how much a tribunal is prepared to award a party who may have invested very little in terms of sunk costs into the project. So I think it is operating at a level that is unspoken and doesn't appear in the awards as a specific consideration, but I think that it is operating. It's certainly operating at the level of funders. Funders, if you're trying to find funding for a case, their first question to you will be, what are your sunk costs? So they won't fund anything where your sunk costs are completely disproportionate to the content that you're looking at.
Would you like to also?
Eduardo Mayora from Guatemala. I wanted to come to Lucas's point on whether arbitrators are not prepared for this kind of analysis, and comment that in most of Latin America, proportionality is a core concept in constitutional law litigation, and it is certainly a very tricky one because courts and judges aren't prepared for that. Because what tends to happen is that the discussion becomes one of public policy rather than law. And so the rights of the investors who become hurt become debatable through the, let's say, the prisma of public policy. And public interest changes over time. Public interest in the short run may not be public interest in the long run. And there's one case where a victim, that one of the judges said something that I think is very important, very interesting. In the long run, it is a matter of public interest to continue to have investors, for the economy to be sustainable, for the economy to grow. And well, probably at this point in time, it was necessary to adopt this particular public policy. But in the long run, if every investment is going to be subject to a proportionality analysis rather than my rights, my legitimate expectations, a right to be treated fairly and equitable, etc., what you all have very clearly described, that becomes problematic. So just to share those comments. So thank you very much for your presentations.
Thank you. So I'm going to go right to the back if I can.
Hi, thank you very much, first of all, for I appreciate that we finally quite for some to stare here. So first of all, many thanks for very interesting discussion. My question is this: so FAT is being criticized very often, much like the investment treaty arbitration system, for being unpredictable. And now we're here discussing how proportionality comes into play here. But I really like the metaphor that you used to describe an FAT as a clown car. So essentially, I think we can all agree that there is no standard definition of FAT. There is no standard uniform definition of the architecture of FAT. And there were some, like many attempts by, for example, Professor Shore and Dolsa, or for example by McLaughlin, Daniel, and Shore to create a system or see or identify if there's a system in how FAT is applied. But my question is this: so, for example, if you look at what Professors Dolsa and Shore wrote, or at what McLaughlin, Daniel, and Shore, proportionality does not really come into, does not necessarily come into the architecture that they propose. So, for example, when we talk about legitimate expectations, they identify certain steps that need to be present in order for the tribunal to make a finding of breach of legitimate expectations, for example. And I would agree certainly with that proportionality may inform this exercise and may refine it and make it more predictable, which is something that the system should strive for. But my question is this: so how do you see this test coming into play? So for example, we have legitimate expectations, yeah, and for legitimate expectations, we need specific representation, we need this representation to be reached, and like where and when does proportionality come into play during that exercise, or should come into play?
Jackie, do you want
Sure. I think the answer is it depends whether you're viewing proportionality as something that can be used to inform the existing standards, so used within legitimate expectations to assess, for instance, the legitimacy of the expectation or the reasonableness of the state departure, or whether, as we're seeing in some of the cases that Lucas and Alex went through, proportionality is viewed actually as a standalone diagnostic tool that doesn't just play into or act as a subsidiary for the other substandards, and instead becomes its own freestanding method of assessing fair and equitable treatment. And if that's the case, then I think that more work does need to be done in investment arbitration case law for developing the particular steps that will be used, whether it's the adoption of the classical model from the European Convention of Human Rights and other human rights bodies that I went through, or whether it's some other assessment. Lucas referred to the terminology that was used in RREE and Spain of suitability and necessity. But in any event, if it is to be used as a standalone tool, then I think it can be a valuable way of assessing, of tackling head-on, is treatment fair, is treatment equitable, without necessarily filtering that through some of the established subcategories such as legitimate expectations, arbitrariness, denial of justice.
So I'm sorry, may I clarify? So your suggestion is that issue of proportionality should be like an overarching element of FET, like a filter that should be on top of the analysis. And once you pass that filter, then you head towards the, for example, the legitimate expectations test, or so like, I don't know, discrimination test, or arbitrary conduct test. Because I'm afraid, like, if we don't try to kind of like make it a step-by-step exercise, then we're just adding another clown in the car, which is already filled. Yeah.
Yeah, absolutely. That's the danger, perhaps, that you're actually complicating what is already a very complicated test. My own view is that I think it's a suitable tool that deserves to be driving the clown car potentially, or at least a passenger in the car. And if the problem is that there is too much in there, then potentially we take out one of the other passengers. Alex, Lucas.
Well, can I just jump in very quickly to say that if one does conceive of proportionality as a sibling concept to legitimate expectations, really quite interesting questions arise. I see legitimate expectations as being an anterior principle. You need that specific representation, and it needs to be at the time of making the investment. What happens after that might frustrate the expectation, but it really doesn't inform its content. So once you're through the door, you've made your investment, you're kind of baked in that legitimate expectations possibility for a claim. But then everything after that, you know, when you have sort of sometimes quite waffly ideas of good faith or reason or arbitrariness, you start to think, well, what does that actually mean, and what type of diagnostic is that providing? And that's where potentially proportionality actually sort of comes in, you know, plays the larger sibling and says, during this period, where the conduct of the state isn't linked to anterior questions about what representations were made at the time, but the conduct of the state is under ongoing review through the lifetime of the investment, proportionality has a real role. I mean, being provocative for a moment and not having thought this through carefully, always a good thing to do when you're speaking on a platform. What would be the reaction to saying, let's get rid of good faith, let's get rid of the component of reasonableness, let's get rid of the component of transparency and consistency, let's get rid of unreasonableness? Suddenly that's a lot of clowns getting out of the car, right? And if you're left then with one driver and a passenger, legitimate expectations of proportionality, if those were the only two components of FET, the clown car would not be too full, but you'd probably get quite a lot of coverage right. Maybe concepts like due process don't naturally fit within either of those. Maybe they need to be, you know, in the bassinet in the back seat. But those two sort of big players, those two powerful diagnostics, could cover a lot of the field of FET. Now, I'm cautious about saying that because I haven't gone away and thought, am I really going to be endorsing getting rid of good faith as a principle of FET? But you do see the way in which treating them as sibling concepts can have a potentially quite powerful occupying the field effect.
Thank you. Can I just take one more question and then we can, of course, carry on the discussion next door, but if you'd like to ask the...
Bank issue from Nigeria. The tobacco lobby argue that the clean packaging regulations are a breach. Now, given the emerging health trends all over the world, is it possible that plain packaging may be extended to liquor and other things? Assuming this kind of issues with plain packaging occur before a tribunal, do you think proportionality can be a sleeping giant that can wake up? And if it does, how do you think it could be used to deal with the issues?
Yeah, so that was obviously one of the topics in Philip Morris and Uruguay. I definitely think that proportionality has got a role to play in this kind of what I call regulatory disputes. And as I said, when we're advising clients, what they really need to know is what is predictable. What are the risks when they're going into a market, because they will factor those risks into their risk assessment of entering into a market. I mean, in the UK, if you read the Gambling Act is about to be updated, and if you read the way that gambling is discussed, it is discussed as a public health issue. It is discussed as in completely similar terms to the tobacco industry. So I think we are moving towards an area where states feel the imperative to legislate and regulate in areas of which cause personal harm to individuals much more readily. So yes, I do see I see more reasoning on behalf of states as to why they're taking the regulatory action that they are, and then I can see in investment treaty arbitration that evidence, that contemporaneous evidence, being taken into account when assessing whether or not a state is exercising its right to regulate appropriately.
Can I add just a quick footnote? I think this is a really interesting question. I was speaking to a relatively senior representative of Diageo, the big liquor multinational, and was speaking to her about what was happening on plain packaging in cigarettes and sort of the litigation, the international claims and everything. You know, she saw the risks that you have identified and said, you know, we may be next, and it's a sort of a domino effect. What may or may not be amusing, given sort of everyone's individual views on alcohol and its effects, was that she said, "But one thing I'm going to do now is go out and make my packaging brighter, and, you know, more fun and more attractive, you know, while I still can." So I don't know what Diageo's sort of most prominent alcohol lines are, but keep an eye out for like now the bright red bottle on the
Things that literally jump out.
yeah, right.
I'm going to end the questions there. Thank you so much for your questions and for contributing, and join us for a drink next door and ask more questions. Before we go, I'd just like to say a few thanks. So first of all, to our colleagues in France and in London who have helped us put together this seminar. Thank you. Your guidance, appreciation and patience with us has been fantastic. Marilee, thank you for hosting us and inviting us. It's always a pleasure to be here. A special thanks to Sonia Morton, who has done a massive contribution to all of us this week, and also to Yana Dorking in London, who's helped us. And Alex and I would like to say a special thanks to Lucas and to Jackie for being our guests today. And it's been a pleasure, as always, to work with you. It's been a real great choice the last week or so, catching up and spending time. We could have spent about 5 hours talking about it. And we're really grateful to all of you for coming out. So please join us for a drink. Thank you.